For pronouncement of judgment, item number 76 to 78.
The appeals do not involve any substantial question of law, warranting admission. Thus, the same fail and are dismissed as being devoid of merit. Many of your matters will go after this Visar build. I think. Yes, but wherein there is a finding of fact. But I must say, these ITT people, they write very good judgments. They are experts, as a domain experts.
This law was laid down by Delhi High Court in Kabul Chawla's case. That was challenged before the Supreme Court.
Yes, Kabul Chawla.
About 150 appeals were pending all over the India.
150
appeals were pending in different.
before the ITT?
No, before different high courts.
Oh.
After Kabul Chawla. That was the law laid down by the company. On that basis, number of appeals were pending.
Yes, yes. One of the members. Make it portable. Yeah.
Item number 79 to 91.
Impugned judgment dated 22nd December 22 as rendered by the learned single judge does not suffer from any infirmity warranting defense. The writ appeals thus fail and are dismissed, being devoid of merit. We'll sign it later. We started getting a print of this permit.
May I please, Lordship? First, in this record, Lordship, question of Lordship 12/9/23 says, Lordship, the service of the respondent, private respondent will come return back, Lordship.
Let the matters be called out. Orders and cases need not be adjourned and mentioned.
No, I'm not.
Lordship, I'd like to mention 71, 72, and 73. Senior advocate, Mr. M.K. Chaudhary is leading us in this matter. He has some difficulties today, Lordship. Lordship will pray for a day's accommodation.
All right. You don't have any problem. The matters have been decided in your favor. You have been given the settlement. Yes. All right. Then what's the problem? A request is made to adjourn the matters on behalf of the appellants who are led by Senior Counsel Mr. M.K. Chaudhary. And counsel for the respondent does not have any objection. List after 6 weeks. Right.
May it please your Lordship. My Lord, item number 74, my Lord. The government has filed an affidavit in opposition on 21st, my Lord. We need 2 weeks time.
Affidavit has been filed on behalf of the state a few days back, and counsel for the appellant placed for some time to file an affidavit in reply. List up 2 weeks as prayed.
Lordship, in item number 44, an affidavit in opposition has been filed on behalf of the state. That may be called for, Lordship.
Call the affidavit.
May it please as your lordship. May it please as your lordship.
Yes.
Lordship, I pray for listing of two appeals matters, unlisted matters. Because there's some urgency. In fact, matters, the matter pertains to medical admission. The order was passed on 27th, and yesterday, matter, a notification was issued cancelling the candidature of the candidates, matter, who have already attended classes for a month now, matter, first year MBBS. Kindly, matter,
What?
tomorrow is the
They are
last day.
pending appeals,
Matter, fresh writ appeal, matter.
fresh writ appeals. So tomorrow,
Today, my lords, last date is tomorrow, my lords. Tomorrow, Saturday, my lords.
why you woken up at the last 11th hour?
The matter, the order was passed on 27th, 28th, the cancel
Order
yesterday.
by?
The learned single judgment.
Okay.
28th, my lords, yesterday evening, they had issued the notification online, my lords, late in the evening, my lords. Prepared.
You have already filed it or you are in the
Already
process
filed.
of filing?
Already filed, my lords, already filed.
Get it listed today.
I'm deeply obliged, very grateful.
Your Lordship, item number 1 to 47 might take along. So my item number is 48. If your Lordship may just permit for an upgrade.
1 to 47, we are not taking first. But yes, in hearing, they will come up first.
but,
What do you want?
My matter is 48.
What do you
So
want?
if your Lordship may just upgrade it.
What do you want?
I just want a little hearing, but that's it.
Hearing out of turn will not be possible. Let the matter be called out. Wait for your turn.
Okay.
Might hope that it will be called out. Don't worry.
Sure, Lordship.
For orders, item 50 and 51.
Please, Lordship. Lordship, in this case, office note indicates that steps were not taken. Initially, Lordship, steps were taken on 16/8.
16/8.
Yeah, I find out from the registry.
Mr. KL submit that he has already taken steps
There was
on
some
16/8. Registry to check and issue notices accordingly.
much.
Item number 52.
Yes,
Last occasion also, my.
record. What happened?
The record, in fact, I have taken the steps, my lord, from my side. On the last.
So what is the difficulty? What is the difficulty, Mr. Das?
Well, they could not find it out, my lord.
They could not find it out means what? Then all right, keep your deputy commissioner present. File his affidavit. Despite,
One more opportunity.
this is writ appeal of 2018. Since when the
I
direction
understand,
for
my lord,
record is?
The record is of 88, my lord. That is a
Yeah.
problem. It's a record of 88, my lord.
88 is not a century ago.
That's true, my lord.
Then
Last sons, my lord, last sons.
on the request of Mr. Das, one last chance is granted for production of the record in terms of the earlier direction. In case the record is not produced on the next date of listing, the deputy commissioner, not Lakhimpur, shall personally remain present in the court. List on
My lord, can you get the-
22nd November,
2nd November.
22nd.
Item number 53 and 54.
Yes.
May it please your Lordship, Lordship, this is a review petition filed by the state. And then in the last order, they have taken time saying that they have to supplement.
We are filing the additional affidavit during the course of the day. My lord. The matter-
500 days delay, you have not explained anything at all.
No, Lordship, they have not explained anything.
In this additional affidavit, we have explained.
And counsel. You are MSK Das?
Yes, my lord.
Submit that she will be filing affidavit for explaining the delay during the course of the day. Additional affidavit. The same be brought on record, list after 1 week.
If you oblige.
Item number 55.
Maybe the Lordship.
54 is along with this. Yes.
Lordship has.
R4 has not been served.
Yes, Lordship, it is answer, Lordship. The address is given by him, Lordship. I am taken the address from the petition, Lordship.
What can be done?
So,
You
Lordship,
file a,
can
procure a fresh address.
Yes, Lordship. To the address of official address may be allowed to take, Lordship.
All right, notices upon the respondent number 4, issued to the respondent number 4 have not been served. Let fresh process be issued and shall be provided thusly to the council for the appellant for effecting service. Rule is made returnable in 6 weeks.
Item number 56.
May I please, Your Lordship. Your Lordship, any service is not completed upon respondent number 4 and 5.
4 and 5. What do you propose to do?
Your Lordship will take dusty.
Notice has not been served on the response numbers 4 and 5. Requisites be furnished within 3 days whereafter fresh process be issued, thus the service is permitted. Rule is made returnable in 6 weeks.
Duly obliged, Your Lordship.
Item number 57.
Yes. 1 and 5 not served.
Lordship, the matter today is, which is listed, wide earlier order dated 22/9/23. Lordship, it was directed to be listed with IA Civil 1648/23 and IA Civil 1630. Lordship, kindly these matters may be listed together.
When was this direction given?
Lordship, 22/9.
22/9. There is no order of that date. Last listing was 1st September.
Connected matters, it was directed.
On the request of the land council for the appellant, list along with connected matters so and so. After week.
Lordship, these are fixed on 4/10, Lordship.
4/10 on 4/10.
Obliged, Lordship.
Whether service has been effected in those matters.
Lordship,
Notice has been served in those matters.
the council has appeared on
Council has appealed. Okay.
Item number 58.
Response number 3 and 4. Service has not been effected. Await return of notice issued to the response number 3 and 4 for 2 weeks.
Item number 59.
Yes.
Lordship, this contempt petition has been prepared for non-compliance of order dated 23 and page 15 is the order, Lordship. Operative part, page 22.
Issue notice. Third, issue notice to the respondent. Steps be taken in 3 days where process be issued. Rule is made returnable in 4 weeks.
Item number 60.
Your representation has not been considered.
Page 12 में था.
Third, issue notice to the respondents. Steps for service be taken in 3 days, whereafter process be issued. Rule is made returnable in 4 weeks.
There is an IFM striking of the name of the petition number 6, madam.
IA number so and so for striking of the name of the petition number 6 within bracket since expired is accepted. Amended cost title be filed in the contempt case number 596.
Deeply obliged, Lordship.
Item 61.
No one is there. Password.
Item number 62.
My lord, here appeal has been filed, my lord, against the order that is passed by the my lord learned single judge.
No notice, nothing. You can do anything under the sky. Principles of natural justice do not apply. That is your argument.
No, the thing is that my lord honorable single judge my lord hold that. My lord, as the cooperative society, my lord discharging the public duty,
So it's come
It's a
under the
state.
other authority, my lord, the Article 12. But our High Court, my lord, already decided in a case, my lord. It is a matter already, my lord, the fact remains that the registered society, my lord, the cooperative society relation of the matter.
Ultimately, the authority to confirm or otherwise the action is the registrar. That is what has been held by learned single judge. That is why principles of natural justice apply.
But the thing is, my lord, this come under the damage. My
Well, let us see the judgment. It's a single bench judgment.
No, division bench, my lord.
Let's see.
It is already decided, my lord.
Let's see.
It is specifically regarding the relation between the, my lord, registrar of a cooperative society and the, my lord, society. And he is not, my lord, appointed by any government department, my lord. He is our employee. It is specifically, my lord, master-servant relation is exists. And that is based on the, my lord, our High Court, Honorable Supreme Court decision. That is reported in 2017, my lord. 1970, my lord. It was also decided.
Just hold on.
No.
Yes, Talukdar.
My lord, my respectful submission is the honorable single judge relied on two judgments. One Z Telefilms, my lord, and the other, my lord, Adi Guru's case.
Question here is that there is a judgment of this court, division bench judgment,
Yes.
which holds that the cooperative society, the employee of cooperative society is a contractual relationship.
Absolutely.
So writ would not lie.
Yes.
How has that aspect been dealt with?
In fact, perhaps this judgment was not placed before the honorable single judge. It was judgment that has been given. I did not appear, my learned friend appeared. But what I'm trying to say, my lord, in fact, this judgment will also hold the field. But in fact, this is a judgment before G Telefilm, my lord. Lordship will take, my lord, into consideration that aspect. So having, my lord, G Telefilms, my lord, been considered by the honorable single judge, my lord, the honorable single judge came to this conclusion that though cooperative society, my lord, is a private body, it discharges public function. So on that count, my lord, the writ petition was held to be maintainable. But so far as, my lord, the other judgment, which has been cited in the, my lord, by the honorable single judge, that is Adi Guru's, my lord, judgment, that Adi Mukta Sadguru judgment, my lord. Now that is of 1989. Now subsequent to this judgment, the honorable, my lord, the Supreme Court had the occasion, my lord, to revisit the principles, my lord, with regard to, my lord, the how to determine, my lord, the public function and public duties, my lord.
Yes.
And thereby, my lord, the Supreme Court has recently, my lord, laid down a judgment considering, my lord, this Sadguru's judgment also, which is very relevant for the present purpose. But I'm placing it out, my lord. This is a case of Ramakrishna Missions, my lord. The question was whether Ramakrishna Mission, my lord, is a state within the meaning of Article 12. Now, in para 29, what is important is the Honorable, my lord, Supreme Court has held, even if, my lord, a private body discharges public function, my lord, the cause of action, my lord, has to be within the realm of, my lord, public law. If it is within the realm of private law, which is governed by common law, my lord, such as tort or contract, then, my lord, public remedy is not available, my lord. If your lordship comes to para 29, this judgment, my lord, holds the field. This is of 2019 judgment, my lord.
Yes.
I'm reading it out. More recently, in KK Saxena versus International Commission on Irrigation and Drainage, this is 2015 case, another two judges bench of this court held that the writ would not lie to enforce purely private law rights. Consequently, even if a body is performing a public duty and is amenable to the exercise of writ jurisdiction, all its decision would not be subject to judicial review. The court held as thus. What follows from a minute and careful reading of the aforesaid judgments of this court is that if a person or authority is state within the meaning of Article 12 of the Constitution, admittedly a writ petition under 226 would lie against such a person or body. However, we may add that even in such cases, writ would not lie to enforce private law rights. There are a cutting of judgments on this aspect, and it is necessary to refer to those judgments as that it is the basic principle of judicial review of an action under the administrative law. The reason is obvious. A private law is that part of legal system which is a part of common law that involves relationship between individuals, such as law of contract or tort. Therefore, even if writ petition would be maintainable against an authority which is state under Article 12 of the Constitution, before issuing any writ, particularly writ of mandamus, the court has to satisfy that the action of such an authority which is challenged is in the domain of public law as distinguished from private law. And para 30 is very clear. Thus, even if the body discharges a public function in a wider sense, there is no public law element involved in the enforcement of a private contract or service.
Come to para 35.
35. It is of relevance to note that Act was enacted to provide for the regulation and registration of clinical establishment with a view to prescribe minimum standards of facilities and services. The Act inter alia stipulates conditions to be satisfied by clinical establishment for registration. However, the Act does not govern contract of service entered into by the hospital with respect to its employees. These fall within the ambit of purely private contracts against which writ jurisdiction cannot lie. The sanctity of this distinction must be preserved. Correct. Yes. Now, your lordship will see, well, bylaw 27 has been relied by the honorable single judge.
Bylaw 27 has been interpreted in this judgment.
Bylaw is not a law, my lord.
What I'm
Has
trying,
been interpreted in this judgment.
yes, I am objecting to the judgment of the honorable single judge. What I'm trying to say that here, assuming that the cooperative society, it discharges public function, but the infraction of the right.
So far as its function with its members are concerned,
Absolutely.
those are public functions, but interstate disputes
Yes,
of
absolutely
its
not.
contractual employees, they
Yes,
would
ma'am.
not come in within the
Absolutely not.
domain of the public.
Exactly, my lord.
So exactly then that is what his argument is.
My lord, I am taking an argument little further by my lord treating this judgment, because what I'm trying to say, the my lord, judgment of the honorable single judge is substantial because these judgments, my lord, which came later on, subsequent to Sadhguru's judgment, was not taken into consideration.
All right,
This is
we'll
my-
admit the appeal.
Yes,
And
and
here
here
you-
stay, my lord, the judgment of the honorable single judge, because it is in conflict with the judgments of the
You are
Supreme Court.
supporting his arguments rather.
Absolutely, my lord. I am, my lord, in fact,
You are for whom?
my lord, I am for the department,
Department.
my lord.
Admit issue notice. Heard on stay application and counsel for the appellant, as well as Mr. Talukdar representing the department, cooperative department, submit that even if the functions of the cooperative society fall within the domain of public duty, but the fact remains that the contracts of service entered into by the society in respect of the employees would fall within the ambit of purely private contracts, and hence, the writ jurisdiction could not have been invoked in relation to such contractual disputes. The matter requires consideration, admit issue notice, having regard to the facts and circumstances as prevailing on record, effect and operation of the judgment dated so and so shall remain in state. In support of his contentions, their contention, they place reliance on so and so. Two judgments have been cited.
Item number 63.
Securitization,
Lordship.
no scope, sir. Absolutely no scope.
Lordship, my concern is that regarding the amount, I am not disputing, Lordship. So I am disputing here regarding my property, the second property.
Go to the DRT, file your application, raise that dispute there. Writ jurisdiction cannot be invoked, sir. Now there are plethora of judgments of Supreme Court.
Lordship, then Lordship, I will take the help of the section 10 of this act, Lordship. Surface Act.
Securitization Act. Yes,
So I will raise the dispute before the bank and.
go and do that. We are not stopping you. No?
Lordship.
All right.
Till then notice may be stopped.
No, absolutely no. We are not entertaining your writ petition at all. What do you want? You want us to dispose of on merits?
Lordship, no, I'll take the help of section 11. There is a method has been prescribed here, resolution.
So
of-
you go there. Who's stopping you?
Oh, Lordship.
We are not stopping you.
Oh, Lordship.
All right, we'll dismiss it as not maintainable. Dismiss, not maintainable. You dictate the judgment.
Item 62, my lord, I was appearing for the caveator. Caveat may be discharged, my lord. No, no.
Caveat is discharged. You're for the employee.
I was the employee.
Item number 64.
So notice में भी कर दीजिएगा. Mr. Mahanta appears for the response. Yes. Change in alignment of road.
My lord, I pray that your lordship, similar case has directed the deputy district commissioner to dispose our representation. Our grievances may be hard, but.
Okay.
Page 24, my lord, our representation.
Amrit Sarovar is entirely different, sir. See, regarding change of alignment of road, the law is well settled by Supreme Court. Writ court is not supposed to interfere. Absolutely.
But we are not praying for the change of the alignment.
Read your
We are
prayer
asking
then.
For the culvert. There was a culvert. Now
All right,
culvert has been stopped.
we'll permit you to get your representation decided.
Yes.
The instant PIL
Page 24. my lord.
has been filed by the petitioners herein, raising the with the
24.
following prayers. Page 12. First up, the petitioners have claimed that before approaching the court, they have submitted a detailed representation within bracket annexure 3 dated 23/6/23 to the Deputy Commissioner Tezpur Assam. However, such representation has not evoked any response from the concerned authority, and council thus prays that ends of justice would be served by requiring the Deputy Commissioner to objectively consider and dispose of the representation of the petitioners
Within 1 month, my lord.
within a stipulated time frame. The prayer so made is justified. Thus, the petitioners are given liberty to present a copy of this order to the Deputy Commissioner Tezpur, who shall, objectively consider and dispose of the pending representation of the petitioners by a speaking order within a period of 4 weeks from the date of submission of this order, copy of this order. In case of any adverse order being passed, the petitioner shall be at liberty to take recourse of the suitable remedy. With the above observations and directions, the writ petition is disposed of.
My lord, in place of deputy commissioner, it should be district commissioner.
District Commissioner, no.
Yes. Development.
Item number 65.
Yes, please.
Madam Chair, I am filing a PIL
Yes.
for regarding the accommodation of prayer room in the airport. In
Well,
other airports, my lord.
what is the fundamental right, sir, in this regard?
According to the section 25 to 30 of Airport Act, there is a certain rules to.
Let us see the rules, please. Let us see. the rules.
Actually, my lord, I am not keeping the record right now. It is available. on
You have to be
the-
prepared. You have filed the PIL.
Yeah, yes, my lord.
For that matter, you'll tell us what should be the nature of the prayer room? Why shouldn't it be our country is a secular country. Why prayer room for a particular community?
No, I'm not filing this PIL for particular community, my lord. The prayer room for the all religions in the Delhi, in Trivandrum, in the Bangalore,
Maybe.
as well as in Agartala.
They
my
may
lord.
have, they may have made the arrangements, but does that give right to a fundamental right? Tell us, PIL can be filed for enforcing a fundamental right. Let us see what is a fundamental right.
In article, it is a violation of the article 25 to 30
Let
of
us
the
see why
Constitution.
it is a violation. Let's read.
Ah.
Read, please.
May I read, my lord?
Mhm.
That the
Definitely.
petitioner beg to state that the Constitution of India expressly guarantees freedoms of conscience and the right to freely profess, practice, and propagate religion to its citizens.
Yes.
The Constitution makers were conscious of the deep attachment of the vast masses of our country towards their religion.
Yes.
The influence it had on their minds and the significant role that the religion played in their lives. Therefore, to eliminate all apprehensions of interference by the legislature and the executive in matter of religions. The right mentions in Article 25 to 30 of the Constitution of India were made part of the fundamental rights.
Yes, we understand. Read 25. Where does it give right to any citizen to enforce or to seek a writ that in every public institution, there should be a prayer room? Please tell us or give us one judgment on that aspect. That the fact that the government has constructed such prayer room in a particular airport or say a few airports, would that give right to every citizen to claim that such prayer room should be constructed in all public establishments? Why only airports then? Why only airports? Tell us.
I am filing for regarding in particular for Guwahati Airport.
We are telling you, we are asking you, why only airports? Why not every public institution then?
It would be better in as well as.
Is it a fundamental right? You have got places to worship. Go there and worship.
My lord, I'm just giving a few submissions.
Yes,
my lord, if there can be a smoking zone.
Yes.
If there can be a spa.
That smoking zone is the purpose is that those smoking people should not damage the health of other passengers. That is why that area has been left apart, not for any other purpose.
I can understand.
Yes.
Then,
So it is to prevent public harm. What is
regarding that,
what is the public harm being prevented by constructing a prayer room?
if a particular place can be demarcated, hardly my lordship for
That's
6
not
to
the
8
question,
feet.
gentlemen. That's not the question. We are again and again asking you, what is the fundamental right to ask for setting up of a prayer room in the airport? To satisfy us, then we'll proceed.
In other airport, it has already been there, my lord. And as part of section 25 to 30, section.
This is
I'm
Article
just-
25.
I'm just telling you the exact section of the airport authority, my lord.
Yes.
It is 12(3)(f). There is a completely arrangement for regarding the establishment of hotels, restaurants,
Yes,
etc.
yes. So it's a commercial activity. Commercial activities they will do. Prayer is not a commercial activity. It's a religious sentiment.
Religion sentiment for not for Islam community, my lord.
No, we are not at all saying Islam. We never said.
Huh,
We just said why for one community.
I'm not talking telling about the one community.
Yes.
I'm telling for entire community, my lord. There should not be any.
That's what we are saying. That there are designated prayer places. The people who are desirous, who have those sentiments, who have those religious sentiments, they can go there and pray. Why should there be?
Where? I'm just giving a few examples, my lord.
Yes.
As my flight is at about 12:45.
Yes.
And our 5 time frame. For example, I'm just telling about the Islam.
Yes, that is why we are putting you the question.
Right.
Yes.
My lord. My flight is at about 12:45.
Yes.
My Johur prayer would be start at 12:45, my lord.
Yes.
At that time, there is some
You should,
rituals is also
you
there,
should,
my
if
lord.
you are so particular about your prayer, then you should choose a flight of the appropriate time. Offer your prayers at the appropriate place and then take the flight. That is your choice. The airports give you a choice of selecting the flight timing.
There are certain flights which I am a regular traveler,
Sorry,
my
gentlemen.
lord.
We are not satisfied. If you want to come back more prepared, where we can give you the opportunity.
Actually, what just I'm coming to the next point, my lord.
Yes.
Actually, whenever I travel in often ways, like Guwahati, Delhi, Guwahati, Mumbai, Guwahati, Hyderabad also, there is some rituals is also there. Until and unless 50 kilometers of the radius, you cannot take the your prayer in advance, my lord. That's why we have been allowed to pray in the flight also, my lord. The prayer timing is confined. There's 12:45. You cannot pray in 12:15, my lord. That's why I need then for the service.
That is why we put you the question, how can this prayer be made or this relief be sought for a particular community? You are focusing on a community now.
No, my lord. I am just telling for the example, my lord.
Yes.
For regarding the non-Muslim for other community, they can also using the same prayer room, my lord.
You give us any judgment or law on this, then we'll consider a prayer. We are not satisfied, basically.
Okay.
Yes.
So please give some time, my lord.
The petitioner present in person, prays for time to prepare and address the court regarding the relief sought for in this PIL. List, how much time do you want?
15 days, my lord.
After 15 days.
Lordship, I am appearing for, on behalf of Mr. SP Choudhury for.
You have not even issued notice as yet.
Lordship.
Relax. 15 days.
Highly of that, my lord.
Item number 66.
No affidavit has been filed, my lord. Only they was given last chance, my lord.
Yes.
Loss of some time. Lord.
We had already given you ample time, sir.
Actually, I am paying for only just to make an inquiry, and if they satisfied, they pay me, my lord. So that is my
That
payment.
excess work you have done. It is regarding that,
Access-
no?
Yes, my lord. Additional work, my lord, there are financial approval is there. Technical approval is not there, my lord, they have not taken till now. So that is their,
All right.
they have satisfied my work, my lord.
And Government Council prays for short accommodation to complete his instructions. Re-notify on 11th October.
Different.
Item number 67 to 69.
May it please your lordships. This matter is ready for hearing, lordships. Any time convenient to your lordships may be fixed after the vacation.
Today it's just 10:50. It's a very convenient time. Start.
Another day, lordship. I pray for another day, lordships, anytime.
Then the matter is ready, but you are not ready. Say so. The matters have been, the petitions have been listed. These writ petitions have been listed after revival in terms of the judgment order dated 24/8/23 passed by Honorable Supreme Court in special leave to appeal within bracket C number 14073/23. And counsel for the petitioners prays for time to prepare and argue the writ petitions list on 6 December.
Item number 70.
In this case, today I have received affidavit opposition filed by the respondent number 11, my lord. And so far the one is concerned, my lord, they have not filed yet their affidavit. One is very much essential.
No, one has already indicated that they are not desirous of filing an affidavit.
No, not
That's
one.
right.
Not one, my lord, two.
Two, okay.
One is, my lord, I have taken this step, and earlier occasion they appear also, they will take time.
Who's
to-
there for one?
One is a
L Devi, central government.
central government.
All right. Whose affidavit has been filed today?
11.
Yes,
Rasmana William, I'm representing Rasmana.
yesterday.
11 being the regional council, college.
Yes.
Okay. So what do you want, Mr. Council? Mr. Manta, what do you want?
I want to be respond these things, my lord.
All right.
And the
Affidavit on behalf of the respondent number 11 has been filed today. Land counsel for the petitioner prays for and is granted 4 weeks time to file an affidavit in reply if so required. List after 4 weeks.
My lord,
It may be mentioned, noted that affidavit has not been filed on behalf of the respondent number 1.
my lord, one prayer, my lord, the respond number 7 and 12, my lord, and one yet to file their affidavit. My lord, the
Respondents numbers 1, 7 and 12 will not file affidavits. And counsel representing the respondent number 12 submits that he would be filing the affidavit during the course of the day.
mass of
Supplementary list, item 75.
So the learned single judge has totally ignored the constitutional provisions and not even discussed the case laws that will be presented. It's a very simple case, the EWS candidates who qualified on merit, they were not placed under the UR. They were otherwise eligible. They were not
placed
in the, they are supposed to be deemed as UR, unreserved category.
Unreserved.
They were not deemed as unreserved. I have pointed out many instances, at least 23 candidates who made the
So,
choice.
meaning thereby upward, vertical reserve, vertical
reservation,
movement.
Yes, vertical reservation, and the ground, if your lordship sees, that some verification was asked from them, my lord, and that verification they said.
So what would be the consequence?
The consequence would be, my lord, that the lesser meritorious candidates, in this case, what has happened is, no other candidate, apart from this petitioner, came on time. No other candidate approached this honorable court, my lord. So, my lord, the Supreme Court is very clear that whoever comes, my lord, if any relief is to be given, has to be restricted to that candidate alone, my lord, in these type of cases. Now, my lord, we have pointed out, my lord, the relevant case laws, the relevant judgment, the judgments, my lord, right from Indra Sani downwards up to the recent judgments of the Supreme Court, my lord. Every judgment is very clear, my lord.
So you mean to say that the rules of reservation have not been followed? That is your ground?
Yes, my lord. We go by 8C of the rules which they are relying upon, my lord, but we say that 8C has not been followed in its totality, my lord. And that is the reason that the cutoff for the UR is, my lords, lower than the cutoff for the EWS. Then, my lord, the EWS quota has been reduced to it is absolutely wasted, my lord, because the quota is meant to pull up those who are below, my lord. This is not a case where, my lords, those who are qualifying on merit, my lord, they will obviously, my lord, have their position.
But EWS do not have vertical reservation.
Yes, it is a vertical reservation. That has been held to be in the Constitutional Bench judgment in Janhit Abhiyan's case, my lord, when this was challenged. It has been held to be vertical.
Okay.
It does not include, for example, my lord, the SC, ST, OBC, etc.
SCST do have vertical reservation.
No,
All others have horizontal. That's what
I'm saying. EWS does not include the SC, ST.
Oh,
it
yes,
is
of course.
Vertical, my lord. So, my lord, no other quota comes in this quota, my lord. So our prayer was very simple, my lord, that those who are considered, and I have given a list, my lord, and that list was given to the learned single judge also, my lord, that these are the candidates who have otherwise qualified on merits, but because of the EWS quota only, they have got in their college of their choice. If your lordship would kindly have the list that I have, the issue would become very clear.
All right.
Your lordship will come to page 240, my lord.
Yes.
Yes, lordships will have the, my lord, serial number 303. Now, this is Sarif Ahmed Chaudhary, my lords. He has got 581. Now, there is a system of marking of choices, lordships are aware.
Yes.
His first choice was, my lords, Silchar Medical College. So, my lord, Silchar Medical College, my lord, the last UR cutoff for Silchar Medical College is 582. Which means that, my lord, this candidate will not get Silchar Medical College if he were not accommodated under some quota. So he has got 581, my lord. He would get, my lord, under his next preference, that is the Borpeta Medical College. So because of the quota, the candidate who is otherwise getting in Borpeta, he has gotten Silchar. There are at least 23 such instances in the present case, my lord. And I am fifth, my lord, in the overall after the last, the EWS. If these were deemed, it is nothing, my lord, it is a deeming fiction. The EWS who gets, my lord, in the college of his choice, he has to be deemed to be a UR, my lord. That is the settled law since Indra Sani downwards. And therefore, my lord, the lower meritorious candidates, in this case, the petitioner, would have to be at least notionally upgraded and given the benefit of the quota, because the benefit of the quota is lost, my lord. When the UR cutoff is higher than the EWS, then the benefit of quota is gone, my lord.
Then we'll admit your appeal. What else?
You know, the some protection.
What protection?
You know, the
seats are counseling is over.
The counseling is over.
Then what protection?
But if
you succeed and if there is any seat vacant, we'll consider what else.
That they can inform. But if not for this year, then at least because the Supreme Court says that if some irregularity is found, and the student has come on time.
We understand. But right now, which seat we will ask them to keep vacant?
That is for
the counseling is already over. Man.
Counseling is over.
Tomorrow is the last.
You have to make a statement that there are seats vacant.
Lordship.
That's for you to make a statement.
Then, my lord, the thing is to be that if I am entitled, if this petition succeeds, as it must, my lord, ultimately, then, my lord, some protection at least for the next year, because some observation, if your lordship doesn't protect me, then, my lord,
next year's seat. This
lordship, my lord, the Supreme Court says it can be done. My lord.
We have our doubts.
My lordship will kindly see.
Absolutely.
But if I may place this judgment, my lord.
Yes. Hope that you will get it decided before next year then. Right now, there's no need to pass any order because next year's seats have not been advertised.
No, my lord, if some observation falls from your lordship, then at least, my lord, that satisfaction I will have, my lord. No, lordship, in this case, my lord, there was a conflict between two division bench judgments of the Supreme Court regarding what should be the relief given to the merit, the candidates, my lord, who comes on time. Your lordship will come to directly, my lord, para number 9. Para number 9 minutes. If I may read, in light of the discussion observations made here and above, a meritorious candidate or student who has been denied an admission in MBBS course illegally or irrationally by the authorities for no fault of his or her, and who has approached the court in time and so as to see that such a meritorious candidate may not have to suffer for no fault of his or her, we answer the references under. That
All
will
right, we'll ask them to give a position of vacancies, if at all. That's
that
what you
my
can.
learned friend is saying that no such.
So far as the EWS seats are concerned, all are filled up.
Because I am not claiming eligibility, my lords, even under the EWS. They were supposed to accommodate the EWS as a deemed UR. So, my lord, one UR seat has to be adjusted as EWS.
It is not even, Mr. Ganguly, the UR candidate last selected will have to make way.
Not
They are
necessarily.
not party.
The lordships will see, my lord, that.
Then we ask them to increase the number of seats.
Lordships, my lord, the Supreme Court allows so much.
Supreme Court can do it
No,
142.
my lord, the Supreme Court has not said, my lord, that only it can do under 142. Even 226, my lord, there is no bar. Lordships will kindly, my lord, see.
Well, all right, we'll see that if that order is to be given, that will be at the stage of final disposal.
My lord, some observation, otherwise, my lord, it will become infructuous.
Observation. What observation? We'll just ask them position of vacancies. That's what we can do.
Look, my learned friend is saying that there is no such vacancy present.
He is not many. He says counseling is over, but still seats may remain.
They can take the instruction.
don't know.
my lord, that on
That
one-
all right, issue notice. Then it standing council. Health appears on behalf of the respondents,
I appear for my lot 1 and 2.
1 and 2. It's Saikya, you are appearing? Yes. All right, the learned advocate general puts an
1, 2 and
appearance
4.
on behalf of the respondents numbers 1 and 4. 1, 2 and 4.
One.
Notice we issue to the respondent number 3. Mr. Saikya, his case is right. EWS reservation, if they get into the UR, they have to be treated as a UR. That is a vertical reservation. That's the concept.
He is deemed as a UR.
Then what happens to that UR seat?
Your seat, it is converted
Converted to?
EWS, so that there is no discrepancy amongst and there is no denial of the EWS category. And that law.
So there will
was
be
settled by the Supreme-
corresponding reduction in the UR quota.
Yes.
Okay. In that
There
event,
is- there is a
they
balance.
don't get the relief.
He will not get, he is down below, absolutely no chance.
No, look, the lordship will kindly have.
He is basically challenging the procedure.
I am not challenging the procedure, my lord. I am challenging what they have done, my lord.
Manner in which you applied the
manner in which.
We have accordingly, as per the rules, we have applied it, and that has been fortified by Supreme Court
already you
judge.
let us know the position of vacancies.
Exactly, Lord.
Vacant seats. Mr. Saikya shall keep available the position of vacant seats, if any, in the admission process
Lordship.
in which the appellant applied. List on steps of service on the respondent number 3 be taken in 3 days. List on 8th November.
But the respondent number 3 has a standing counsel, Mr. B.K. Boydeo is there. We have
Right.
sub copy to him.
Sir, the copy, the service upon the respondent number 3 be effected by providing copy to standing counsel, Mr. Church.
The lordship has listed it on,
8th November.
can it be before the vacation, my lord? They only to take. the
9th,
instruction.
all right, 18th October.
Highly obliged, Lord.
Ostobarometer 61.
Yes.
May I please, your lordship, my lord, this case relates to, my lord, the setting up of brick clean industry, my lord.
Yes.
This appeal has come against the order of the learned single judge.
Yes.
My lord, the holding of the learned single judge is that, my lord, he did not find any reasonable grounds to come to the conclusion that the consent to establish as well as consent to operate was issued in favor of the private respondent was illegal and not in accordance with law. Here, my lord, we approached before your lordships to consider whether the certificate issued by the assistant settlement officer, secretary of the concerned Gaon Panchayats, and the distance certificate is as per law, my lord. That is the question to be decided, my lord. As because the lordship will file the impugn order, my lord. At page, my lord, 32, page from 34, my lord, paragraph 11.
Yes.
Paragraph 11.
Yes.
The first objection raised by the petitioner's counsel is on account of the fact that the brick lien has been established over agricultural land. There can be no doubt or dispute about the fact that in view of the provisions of section 3 and 4 of the Act. Act means, my lord, Assam Agricultural Act, my lord, regulation of reclassification and transfer for non-agricultural
Yes.
purpose in 2015, as well as Rule 3 of the Assam Brick Kiln Establishment and Regulation Rules 2013.
Where is that certificate? The
My lord,
certificate which is
yes,
referred to in this order? Where
Yes,
is-
my lord. The certificate is, my lord, page, my lord, yes, page 70. Page 72. Assistant Settlement Officer.
Yes. So it is proposed to be resettled
No, my lord,
as.
page 65, sorry, my lord, page 65. This is the certificate, non-irrigation land certificate issued by the Assistant Settlement Officer.
Yes.
Hailakandi, Lala Sakun. Certified that land measuring an area of 8 bigha covered by that number so and so against second periodic patta number so and so more than
Yes.
part one.
What has happened to the third, this resettlement operation finally?
No, my lord, third resettlement operation has not yet been done, my lord. This certificate was issued, my lord, on 6/8/2018.
Or issue notice to the respondents. Standing counsel, Mr. Nath appears for the so and so.
I appear only for 4, 5, 7.
4, 5, and 7. Step for service upon the other respondents be taken in 3 days, whereafter process be issued.
My lord, may I please your lordship, my lord, may I pray your lordship, my lord, further process of issuing consent to operate, my lord.
No.
As
We
because-
will not stay anything right now.
My lord,
Let the other side come.
My lord, the
You have
petition-
failed before the writ court. There is no question of grant of stay. Sorry. We'll
lord,
dismiss your prayer, then we'll reject your prayer.
My lord,
Wait. Let the notice be served. We'll hear the other side. Then we'll see.
the renewal of consent to operate has come in on, my lord.
20 is also very much there of the implement.
We have seen that. All right, the prayer for interim relief is refused.
As your lordship pleases, my lord. As because my lord, consent to operate, renewal of consent to operate has been, the
Let the
process has
authority
been
decide.
going on by the
Yes.
PCB, my lord. If the consent
From
to-
which year the brick lane is functioning?
As your lordship pleases, my lord.
Uh,
This is my humble prayer before your lordship.
No, we are not granting you interim relief. Thank you.
Much obliged.
Daily list, Portrait matter 1 to 47.
Lordship,
Yes, please.
Lordship, if I may, just before the other side were in rejoinder, if I can just inform Lordship.
We had called for the record.
It's come, Lordship. It's
Yes.
The record is here also, Lordship. And just I wanted to apprise Lordship about one development since I last argued the matter before Lordship. I had apprised the Honorable Chief Minister about the concerns that were flowing with regard to the investigation and whatever Lordship had stated on the other day. Now, Lordship, the Honorable Chief Minister yesterday has taken a decision and formed an SIT under a senior IPS officer, Lordship, because our attempt is nowhere to shield anyone or anything. And Lordship, that order which has been taken out by the DGP yesterday evening has also been issued. And what I've been told also, that is, of course, I can share that order for a minute if Lordship would permit.
Please, we would like to see it. This must surely be what you are saying. We would like to make it very clear. We are not very satisfied. And one more observation, of course, let's have a look at it. Okay. Yes. This, as a matter of fact, fortifies what we were all along observing. We're not making any comments on whatever investigation, but there are many things left to be decided. Many things. It's a fact. You can't dispute.
That's why, Lordship, I brought everything. I thought it was appropriate to, that these things had to be shared. And Honorable Chief Minister immediately took that decision. I may also, it's not in the order, but I may just for, as my duty and to inform Lordship that what the Honorable Chief Minister has directed is that it should try to be finished within 6 months, that there has to be done in a finite period. So I thought if I can bring it to Lordship's notice, rest we are of course in Lordship's hands as Lordship would.
Mr. Mishra, what should be done in view of this development? SIT. Can we wait for making certain observations based on whatever has been argued before the court? Can we ask the SIT to give its preliminary report in a sealed cover for the court's perusal? Would it not be appropriate? Because whatever is decided may or may not have very far-reaching consequences.
Very far reaching.
So for that purpose, if now there has been a change we would say not in stand, at least change in investigation. And if the court says that certain facts which the earlier investigating officer has not investigated or has chosen to sit over, they should be brought on record. Would it not be appropriate?
Well, the difficulty.
Because decision of these appeals, one way or the other, would foreclose the right of either of the parties. May. We would not say would.
So far,
may.
So far, the appellants this side is concerned.
Yes.
They are in a very precarious situation.
That's what we are saying.
And I can tell my lord what has come from him and what we heard, nothing to prove, very difficult, something to substantiate. I'll only say that in Clash of the Titans, these young people, they have been crushed. I'll say that.
Not so simple, Mr. Mishra, not so simple. You see, you've got a lot more experience than me on the criminal side. You very well know what is the effect of those recoveries. You know, the fact that the two answer scripts in the writing of the same person are found, what inference would that give? So broadly, what is bothering us is whether only these persons should be singled out or whether the effect has to be
all pervasive.
All pervasive. So,
my lord, what has come from your lordship, if the grain can be separated from the chaff, that's what
whether it has been done or not, that is the question.
It hasn't been done.
So that is why we are saying that if we can ask the SIT to come out with a brief report on the basis of materials collected so far, that whether the so-called separation has been fair and transparent.
Yes. Then that will be fair enough.
So that because
there are others also.
Yes. So we'll call Mr. Das.
Yes, it will be fair enough.
Yes, that's what we feel that it is necessary.
Because if your lordship remembers Krishna Yadav's case.
Yes.
In Krishna Yadav, similar allegations were there. The High Court did not go into the matter. High Court gave some relief and then said appointment up to this, no more. When the matter went to the Supreme Court directed the CBI, directed the Haryana government to refer the matter to CBI, and CBI made a report.
Yes.
And on the basis of that report, because the persons who were selected, they were already terminated. They were terminated. They were already appointed. Already appointed. And after this, Krishna Yadav's judgment, they had to be terminated. So a question arose in Krishna Yadav, what would happen to those persons who have already been selected? So the court said, see, we are not trying to find fault with the individuals. What we are saying, we are cancelling the entire thing. Therefore, if your lordship remembers, in my argument and the decision that I have submitted before your lordship, I made it very clear that notices will be required if individual is faulted.
Yes.
And
that we know, we recollect that argument.
Yes.
Even Ms. Colley has said so. Yes. That it is no if the individual is to be targeted, yes, notices are required.
Yes.
But if it is a decision is all pervasive, the entire process goes, no need of following principles of natural justice.
So, madam, I only hope that at least the position that we are in.
We are not closing anything. We are not closing anything. Let's have a preliminary report. Then we can.
I have absolutely no difficulty.
Call Mr. Das and Mr. Chaudhary.
No difficulty.
And in fact, lordship, just because what I had said also, and just to reaffirm that, and that is why these developments is, there is no intent at all to shield anybody.
Mr. Kohli, frankly, we will say that you argued everything on principles, but nothing on facts. You just, you refer to the YouTube, you are all along arguing on principles. Thank you for enriching our knowledge. But it's a fact that you have not touched the facts, how findings have been arrived at by the learned single judge, nothing. And how you make a distinction. So let the SIT come out.
I'm in lordship.
And we are again saying so in loud and clear that we are bothered about the conduct of the IO in sitting tight on that 9 pages sheet. What is the evidence against those persons from that sheet who have been left out?
That is exactly what I've shared also, Lordship, and that is how the Honorable Chief
yeah,
Minister said, it's that 9 sheets.
Absolutely, we understand.
My lord, one of his argument disturbed me. He says that Article 31, 311(2) is subject to policy. The constitutional provision, constitutional protection, can it be?
He was simply trying to enrich our knowledge.
My lord, even
if I try and fail, it's an
Ms. Kohli, we really appreciate that whenever these celebrated judgments are read and reread, you gain something every time. Mr. Mishra had the occasion to make us go through the principles of 27 Evidence Act in another case. So that was an enriching experience, we must say. We learn every day.
I'm very obliged.
Even
Like, Lordship was
42nd
at one
Amendment
point-
cannot do away with those 3 requirements of second provider to
Mr.
Article
Das,
311.
Now, there's been a significant development yesterday.
Yes.
Under the directions of the Chief Minister,
I have a copy.
SIT has been constituted.
Will be here.
So it is still loud thinking. We feel that in view of whatever arguments have fallen from you, we would direct the SIT to give a preliminary report primarily on the aspect whether there is a distinction in between the appellants herein and those people in those 9 pages list regarding whom the IO set tight.
Yes,
So an interim report to that extent.
but this will be kept pending.
Yeah, of course, we're not closing anything.
And my lord, one thing, my lord, yes, so absolutely no problem. My learned friend, as your lordship has allowed my learned friend to file, but I have seen the affidavit. He almost covered all from paragraph 1 to last. No, my lord, your lordship has said only deal with those paragraphs which was not brought before the learned single judge. Now I have seen all these paragraphs which is already argued.
This is what Mr. Kohli has done in the writ petition also. The earlier
If I may,
affidavit was
Lordship, in fairness, the first part, just on a lighter note, I'm not finding fault with that. On a lighter note, the first part is exactly what we've reproduced in the other. The paragraphs that are new, 39 onwards, Lordship, that's the specific one. But I have to do my duty of completing it.
My lord, then my lord, he has brought documents.
We'll give you opportunity if anything new has been brought in. We'll give you opportunity. Definitely.
In fact, my lord, if I may say, your lordship is proceeding in the same line as in the Preet Singh Kohli. Supreme Court asked, because this will separate tented from non-tented. Absolutely fair.
Yes, Mr. Patwari.
Yeah.
What is?
My lord, as regards the SIT, my lord, I don't have any objection. But
No, we are not on the aspect, we are not questioning the validity of the SIT.
No, my lord.
We are saying that we want to wait for a preliminary report from the SIT. So we are not deciding the petitions.
No, my lord, but what about the records of the governor, decision of the governor?
They're all here.
That should be kept with the registry, my lord.
Why?
As Lordship directed.
No, we are not going to burden our cupboards with those records. They are all confidential records. We can have a look at one of the files, please. You can show us any one file, just for our bare satisfaction.
Just to see the decision-making process.
That's all.
And they'll come whenever, Lordship.
So obviously. Mr. Chaudhary, there's a new development and a significant one at that. It seems that our YouTube uploading has reached the concerned people who take the decisions.
Right.
So yesterday evening, the SIT has been created, constituted. So our proposal is that we ask the SIT to give a preliminary report. They have sought 6 months' time, as per Mr. Kohli, to give a preliminary report for the court on few particular issues, which we will indicate in the order.
Fill up the blanks now. Fill up the blanks now.
Yes.
I do not say pretty category. They are trying to separate the
What has happened to Ms. Kohli? What has happened to this Pavitra Kaibrata, Assistant Controller of Examination, APSC? What has happened to him? Is
He's
he
charge sheeted accused, Lordship. He's a permanent employee.
he's a permanent employee? Whether any DP against him?
I'll have to. This is, I think, an APSC employee, Lordship.
Yes.
Yes. So, Lordship, I don't appear for APSC, Lordship. I'll have to find.
Because
I will assist,
see,
Lordship. Request.
these are the two people who have set the ball rolling.
So there was a DP in the case of Navakanta Patil. I remember that, Lordship. This person.
DP has been done. Yes, on the last date, you didn't make any such statement.
No, Lordship, I just merely pointed out on the last date because his example was given that he is not one of the persons who appeared. He's an older employee, permanent employee.
We understand.
And
but
he was charge sheeted also, I pointed out.
he is not to be proceeded for. Whether he deserves to remain in job.
Lordship, I can't speak for that for the government as Lordship understand. That's the APSC, Lordship.
Yes. These are this is a sanction file. This is a file pertaining to PS prosecution sanction.
We can show other files, Lordship. We just picked up one random.
No. We were asking you discharge. This is the discharge file also. Ms. Kohli,
Lordship.
we are passing on this file. Please flag the papers.
Yes, Lordship.
Where there is a discussion on the aspect of discharge without notice.
It'll be done. It came late yesterday, but I will do it for that because.
So you hand that over the flagged document at 2 perhaps at 2.
Today?
Yes, today.
Of this particular file, all files, as Lordship said.
Any 1 or 2, 3 files.
We'll do
1,
that.
2, 3 files.
2, 3 files we'll give.
Yes.
At 2 o'clock.
All right. The matters were today posted for receiving affidavits on behalf of the fresh affidavits on behalf of the respondents. And in the case of that you were to file an affidavit in one case, Mr. Das,
Yes.
in so and so. You filed the affidavit?
No, we are going to file it.
Affidavit, fresh affidavit has been filed by Mr. Kohli. However, Mr. Das appearing in so and so submits that as few new details have emerged in the affidavit of the state, he requires a week's time to respond. Stop. During the course of hearing, a fervent argument, the following pertinent arguments have been advanced. Ms. Kohli has placed on record copy of the order dated 28 September 23, issued by the Director General of Police, Assam, as per which, a special investigation team within bracket SIT has been constituted with the reference to the letter of Honorable Chief Minister of Assam dated 28/9/23 to investigate the Dibrugarh police case number 936/2016 First of, as per the oral instructions received by Ms. Kohli, the SIT is proposing to conclude its proceedings / investigation within 6 months. First of, we may note that during the course of submissions, it was the emphatic contention of the senior counsel representing the petitioners that the investigating officer, while and the state officials, while undertaking the exercise, so-called exercise of separating the chaff from the grain, grain from the chaff, have acted arbitrarily. First of, whilst the appellants herein were singled out for the punishment of discharge, other people, other similarly situated candidates against whom the investigating officer was possessed of significant evidence, were left out. It is further informed that even the 2 government employees who are namely Nabakanta Patir नाम है ना उसका क्या है? Patir and so, the उनका description दे दिएगा, who were apprehended red-handed while accepting bribe so as to influence the selection process in question, have not been proceeded with, whereas the appellants herein who are young selected officers in the 2013 APSC batch have been discharged from service without following the principles of natural justice. First of all these submissions were emphatically controverted by Senior Counsel Ms. Kohli, representing the state of Assam. We feel that in order to give a fair treatment to all concerned, it would be apposite to direct the SIT, Chief SIT or SIT constituted by order dated 28 September 23 to give a pertinent report, interim report for the perusal of the court in a sealed cover on the following points. Number 1, whether the decision of the investigating officer to separate the cases of the appellants herein and those candidates whose names are incorporated in the 9 pages sheets.
9 pages
tabulation sheet is based on any logic / rational. First up, the reason behind the investigating officer not forwarding the documents / answer sheets of those left out candidates whose names are reflected in the 9 pages tabulation to the FSL till 2019. Number 3, whether the state government has proposed to take any disciplinary action against the left out officers as per the 9 pages sheet who were not discharged along with the appellants herein. Number 4, whether from the evidence collected so far, any other cases have come to light of candidates who too secured selection by fraud. Anything else to be added, Ms. Kohli? You can suggest.
I think
Sure. Anything which comes to mind.
I just want to point out, there are allegations that duplicate answer sheets were not printed in the government press, were used.
That is an argument. That is an argument which they have tried to contest.
No, what they have not done is, They say that the
That
answers.
would be for the criminal.
My lord, no, I'm not going on to that. I'm saying, because that goes against us here. They say that these answer scripts are not printed by the government without looking into whether the original answer script were printed in the government press or all other, any answer scripts were printed.
That document, Mr. Kohli has shown us. They were all printed in the government press.
We have not been.
I have annexed it in the reply just now that I put.
That, of course, I didn't get.
The affidavit,
It's in this reply.
give a copy to Mr.
But I'll give a copy.
Mr. Vishal.
I'll share that.
Share a copy. of the affidavit.
No problem.
I was just wondering one thing. The fact that Lordship is directing a new exercise. That means the exercise which was undertaken was faulty.
Not commenting anything without the aforesaid exercise shall not be considered to be a comment on the veracity of the earlier investigation, because the said decision would be taken when the appeals are finally decided. Don't prejudge the things, Mr. Chaudhary.
I am
This is
deeply obliged.
An interlocutory kind of order. We want to be satisfied fully if the excise earlier taken was above board or not. Re-notify. How long would this take as?
What would Lordship like? What is convenient to Lordship?
This should come out in 4 weeks maximum.
Perhaps 6 weeks, Lordship. Give us 2 weeks for at least the handover for them to start studying the documents, because I think 6 would be, Lordship.
All right, re-notify on
After the Diwali holiday.
after the public break. 16th November.
First step towards doing substantial.
16th November, if I may.
This is first step towards doing substantial justice.
May I respectfully, Lordship, just request 16th November, that's Diwali time for us.
Diwali holiday, Delhi lawyers will
Yes,
be
that's why I was
enjoying
saying, Lordship, after.
20th November.
Yes, is that. That's why I was saying 22nd,
22nd.
I'm so. And I'm deeply obliged, Lordship, for that opportunity, and also Lordship for that comment that they can do their work fearlessly. It's not being a comment on the merits. Otherwise, it would have an impact on
My
that.
lord, can it be permitted to inspect the record, the decision-making process?
You can apply in RTI.
Or you can be, juniors will be permitted to. just
Kohli,
have a look
what do you
on
say?
In front, in presence
you
of-
Lordship, I don't have instructions. My problem is I have to seek instructions.
Take instructions and come back at 2 and make a statement. then.
At 2 AM, I'll say.
At 2, otherwise also, we have requested you.
Yes, of course. So basically, Lordship, the difference is I'm flagging 2-3 files. If it is for all the files, then I need to ensure
No,
that.
you want to inspect all files or 2 or 3
No,
files?
the decision-making process part, maybe 2 or 3 pages.
2 or 3 pages.
Whichever, Lordship. So Lordship, I'll take instructions on that, Lordship.
Then if you identify that this is the page, we just go through.
He will have to take instructions.
Yes.
Then he can revert at 2.
Maybe a 2.
Very well. Okay.
Mike, I have a flight. My colleague would be there, Lordship, if it's okay.
You have flight at what time?
My flight's later in the this, but I want to go to this full, Lordship, before this, because I have some work to do on this also, Lordship.
Okay.
If Lordship would permit, otherwise I'm here. At
No, it's okay.
Prayer is a must before. Prayer is a must before flight.
We heard that, Lordship.
Yes.
We can pray here.
Prayer is must, yes.
We are praying here to Lordship. All right. I'm so obliged to Lordship and Ladyship. I think it will. Yeah, right.
Yes.
Yeah. You're waiting for that.
Item 48.
What is this coming for?
Your lordship, this is a PIL which was pending since 2018, pertaining to the health issues of the transgender community.
Yes, Mr. Nath. Mr. Nath. Who is
Mr.
appearing in
JP
this?
Bora,
Mr.
he
Bora
was
will be
given
appearing.
standing.
All right, Mr. Bora will be appearing. We thought that Mr. Nath was appearing in few of the matters.
No, my lord, I am appearing for the health department, but central government council is also required, my lord, Mr. RK.
Okay, you were appearing in the other matters that
I'm
transgender,
saying the other,
transgender board.
not in this.
Okay.
Lordship.
There was one matter wherein you had produced that photographs. Which was that
That
matter?
was regarding PIL 2.
Okay, why is not listed today?
It is listed for 13th October.
Okay. We were more concerned about that as a matter of fact. That was very serious. as a
Yes,
matter of
in fact, after that incident, your lordship, there are 2-3 police stations which just came up.
Yeah, there's one flip side also. Now people are posing as transgenders and are misusing that. That
In-
is also happening.
In that regard, your lordship will be amazed to know that recently the Transgender Welfare Board committee members has been reconstituted. And whereas a gay person who is now impersonating as a transgender, he has been appointed as an associate vice chairperson by the government. Now, where the NALSA clearly talks about when this entire matter was deciding, the Justice K.S. Radhakrishnan clearly spoke that third gender means transgender, not gay, lesbian, and bisexual.
That's right. That's right.
But even though a gay person has been inducted there,
You challenge that appointment.
no, that appointment we are coming up with that very soon.
Okay. So what is to be done in this
Here-
one today?
Here in this PIL, what has happened is, your lordship, the government of India came up with an health insurance scheme.
Where is the government of India?
Mr. R.K. Dev Chaudhary is appearing in this matter.
He has to be here when the matter is called out. What is this?
But he's coming.
It's coming. Yes, all right, you carry on.
Yes, Your Lordship. So the government of India came up with a scheme which was known as Pradhan Mantri Jan Arogya Yojana. In short, it was known as Ayushman Bharat. Ultimately, which was implemented by various other state authorities, state governments, and simultaneously the Assam state government also implemented the same. In that state scheme, your lordship will find there are many packages regarding health. One of the package was known as reconstructive surgery. Now, when we started doing a research towards reconstructive surgery, we found that sex reassignment surgery is also included under the reconstructive surgery.
Okay.
But when we question the state government, who is the implementing agency, they say this scheme is based on two census data. That is to 2011 caste census data. Now, the government, the implementing agency told us that the data which was recorded under 2011 caste census population, according to that data only, we will be able to provide them. But there is again a confliction because there was two population census which was taken place in the year 2011. One was caste census and another is the 2011 population census. 2011 population census talks about the transgender has a total population of 11,374
In the entire country.
in 2011
In state of Assam? Or
in the state of
state
Assam.
Okay.
But whereas the caste census population, the caste population census, which was divided into two categories, urban and rural, it only says that Assam has a transgender population of approximately 1,500 or 1,100 approx. So that is again a confliction. Now, after we question the government of India, this was prior to 2019 Act of Transgender. So when we question the government of India that whether transgenders will be having these facilities under the Ayushman Bharat or not, they said no. And then simultaneously we came up with this PIL challenging that policy decision.
Okay.
But after that, what happened? In the meanwhile, there was a core committee constituted by the National Human Rights Commission. They also suggested the government of India that transgender cannot be avoided. It is a clear violation of Article 21 of the Constitution.
That's right. Okay.
And after that, various other recommendations from the other governments and the institutions and machineries of the government of India. Simultaneously, in the meanwhile, 2019, the Transgender Act came into place. And Section 15 of the Transgender Act now clearly says that the state government has to change the MBBS syllabus as well, and they have to include the various other package and procedures that are pertaining to a transgender treatment will have to be implemented.
Okay.
But this has not been done. Now, what problem we are facing is, Your Lordship, in each and every medical colleges, there are only two words, which are specifically for the non-gender binary norms, male and female.
Yes.
Now, suppose if a transgender has any serious ailment or met with an accident, where we will be able to admit him or her? That is the first question.
There's been an issue whether you place the transgender in a female ward or a male ward.
Yes,
Either ways.
that is again a question.
Yes.
Because ultimately, why this question has arisen? Transgender has got many other categories.
Yes.
Some of them undergone a surgery and they converted themselves to be a female. Some became a female to male,
Reverse.
who are known as trans men.
Yes.
Some of them are the Kinna community, some of them are the Hijra communities. So therefore, this will be a robust exercise if the government doesn't take it seriously. And if your lordship, there is again a serious problem in the issues is regarding the expertise. Now, suppose I being a trans, I converted myself from a male to female. Now, suppose I am on hormone or I am certain other medications which are required for my transformation or transition. Now, in that case, suppose if I have a fever. Now, this is not like a normal medical practitioner that only just providing cetirizine or paracetamol will help a trans, because that has to be taken into account that whether the candidate is under medication or not, what if I suggest paracetamol, what can be the side effect? All this has to be taken in account.
So basically, you would suggest an endocrinologist should be there for the treatment or providing even routine medication. Some specialization.
For transgender treatment, your lordship, a group of doctors are required, starting from endocrine, then gynecologists, then plastic and cosmetic surgeons.
So basically, you are asking for a specialized ward in each government hospital.
Ward. Apart from that, your lordship will find in the previous order that the state government has clearly said there are 6-room ward has been constituted. And more surprisingly, when I visited the Guwahati Medical College, I didn't found any such word pertaining to the transgender community, which they have stated in their affidavit. Now, your lordship, some may think that whether in any matter, why the history of transgenders are brought into place, but why the history is important is the genesis is required. The genesis has to be very clear pertaining to the transgender community so as to ascertain what discrimination the entire community has faced for so long.
That's right.
Whether in the judiciary, whether in any public appointment, even if your lordship travel to our Guwahati city, you will find, your lordship, even if for any requirement, for any public toilets, there is only a male and female. We don't find any transgender toilets is there.
That's right. That's right.
We are been getting restricted from everywhere. The NALSA judgment clearly talks about that, starting from right to marry, right to education, right in everywhere. But why where the state government is heading towards? The state government has formulated a welfare board a long back, but which is still a toothless. That is again a questionable fact in the matter of PIL pending before this court. So therefore, from each and everywhere, we
suggested, you give out 2 or 3 bullet points, and we will ask them for compliance on the next date. Mr. Bora, what has been argued regarding a specialized ward in the hospital? That should be a first step. You have got it. Where is it? Show.
My lord, in our affidavit, my lord, filed on 14/12/2021, my lord.
Yes.
14
Page
4, my lord.
An affidavit at page number.
Affidavit 14/12/2021, filed on.
14.
Filed by the Joint Secretary to the Government of Assam, my lord.
Has the Government of India filed an affidavit?
Yes, my lord, they have also filed. So in our affidavit, we have stated that, my lord, 4 rooms in the medicine ward has been specifically allotted to the transgender community with separate toilets, my lord.
Not only toilet, you have to assign doctors.
No, doctors.
Specialized
my lord.
doctors.
My
Where
lord.
does your affidavit say so? Let's see.
Affidavit dated 14/12/2021, my lord. paragraph, page 3, my lord,
Just a moment. 14/12,
2021, my lord.
343. Affidavit file अलग है क्या? जाके there is separate file. It talks of page number 343. There is no such page in it. See. And what has happened to the last date? You made an argument regarding discrepancy in February, discrepancy in the numbers, census.
Yes.
That has not been addressed as yet.
That is not been addressed. Your Lordship said that as a last chance, if the government fails, government of India fails.
Then let him say that.
Lordship, in response to that order, Lordship, I have filed my affidavit.
You already filed.
Yes, yes.
When?
That was filed, Lordship, April 2022.
23rd May. Yes, that is affidavit.
Yes, Lordship.
You got a copy?
Yes, yes.
23rd May.
Yes.
Now, so far as 2011 census was concerned, Lordship, if I may take your Lordship to paragraph 2 of my affidavit, 3. More particularly to 3.
You only said there is no cause of action to modify. That is the affidavit.
Lordship, here, there was no specific Lordship category for transgender, Lordship. It was others. That is why there has been a discrepancy, Lordship.
That's what the
Now,
grievance
Lordship, that
is.
it has already been published. At this point of time, it may be in the next census, Lordship.
That will be 10 years later.
Lordship,
Okay.
this is 11, Lordship.
So your next census when it is, sir.
Lordship, actually, it has to be 2021, so it is not yet published. I can take it up with the authorities that it can be included. But
They should have done this exercise by now. If the report is to be published, census is to be published. If they have not done the exercise, what will happen now? Another 10 years down the line, down the drain.
Your Lordship may just see my first.
So what you say in the affidavit is, you read the affidavit, it is important to note that the census of India does not collect any data specifically
on transgender.
on transgender.
Yes, Lordship.
So how would you carry on the census? This is a third gender now, no doubt. So when you are conducting a gender specific census, how can you exclude them? In what category will you keep them? Is it not a flaw apparent on the face of the record?
As on date, Lordship, yes.
Then
So far as Lordship, 2011 was concerned, it was under that. because
forget
this-
about 2011, thereafter you brought out the act.
Yes.
So it's
Lordship. Now-
recognized as a third gender.
Yes,
So
Lordship.
third gender, if you are recognizing, there has to be a census, no doubt.
Yes, Lordship.
So your affidavit says that we are not doing it.
So far as 11 is concerned, Lordship.
Will you read? This is in reference to 2019. Reply. Read page, your affidavit, second last page. Minister of State for Social Justice Empowerment.
Lordship will read from the italics, the Registrar General of India during enumeration of census 2011, Lordship. For the first,
The bold part.
Yes.
It is important to note that the census of India does not collect
Yes,
any
Lordship.
data.
Yes,
So this is a perpetual statement,
yes,
statement in perpetuity.
Now your Lordship may just see page 189 of the main PIL petition.
189.
What is it? Tell us. Before that, let us see the affidavit of the state regarding the facility in the hospital.
Yes, my lord. Page 3. Affidavit filed on 14/12/2021, my lord.
Page?
Page, my lord, page 3, my lord, subclause 4 is, it starts. The transgender community will be provided free investigation and treatment at GMCH, Guwahati Medical College Hospitals. 4 numbers of medicine paying cabins, whole block in medicine have been allotted for the transgender community in GMCH, with each cabin having a separate toilet, and the patients will be seen by a dedicated team of doctors, nurses, and paramedical staff. So other measures also that the state government has taken, my lord, that has been described in the affidavit, my lord.
If your lordship may just see their affidavit, apart from this one paragraph, it only talks about HIV, AIDS everywhere.
Then what you do is that you file an affidavit, maybe go and have a inspection, then come out with a pertinent affidavit.
We have mentioned each and everything, and
Wherein?
we have replied to all their
You replied in affidavit dated. What is the date of your affidavit? What you do is, Swati, what you do is you flag these documents and
Yes,
affidavits
because
and prepare a brief
Huh.
and come out on 13th. Okay, 13th we'll have it with the other PIL.
Yes.
Then we'll pass the necessary directions.
Yes.
Okay.
But
Prepare a brief.
but before that, your lordship may just see 2-3 points, which I
Yes.
will bring to the notice of this court.
Hmm.
Your lordship may just see once page 89, 189.
189.
Page 189 is not there in the mail PIL petition, my lord.
A paper book has been prepared probably. She is referring to that. You are referring from the paper book,
Yes, lordship.
189. Yes. You're not having it, Mr. Bora.
Yes, my lord, I have.
Then read from the paper book.
Yes, my lord.
Page
It is
189.
transgender in India,
Yes,
Assam.
that this is the
Chaudhary.
2011 population census.
Ms. Chaudhary, this is census.
Yes, my lord.
So then you said that you are not doing the census in this manner. Your affidavit is contrary to your own document.
11.
She has downloaded the copy which I explained, Lordship.
Yes. What have you explained? You said that we never did a census focusing on the number of transgenders. So how come this number came? From where this number came?
This is a downloaded document from
No,
their website itself.
We are suggesting to prepare a brief note pointing out the discrepancies with reference to their pleadings. Then we'll pass the necessary directions. Okay. The petitioner present in person shall prepare a brief note from the pleadings / affidavits / documents filed on record till date, highlighting the discrepancies and the shortcomings in the action required to be taken under the statute / judgment of the Honorable Supreme Court in the case of Nalsa case, in Nalsa case. Re-notify on 13th October. Advance copy of the brief note shall be provided to learned counsel representing the respondents. Come back on list on 13th.
Obliged, Your Lord.
Item number 49.
Yes.
This can I kindly take after these vacations, my lord.
After vacations, what is it supposed to
My
be?
lord, we are paying for a direction to respondents, my lord, to regularize our service, my lord.
Okay.
We are the employees of.
List after puja vacation. As
My lord. I am obliged.
Mr. Manta, where is your file? You made a request in the morning. Where is your file?
My lord, it's on its way, my lord. 10 minutes more, my lord. Or otherwise, my lord will take it up at 2 o'clock, my lord.
We'll come back at 2. हो गया ना बोर्ड हो गया
All files are with us, Malad. I have taken these two files.
Okay.
And Malad, I have been instructed to inform the Honorable Court that these are for the perusal of the Honorable Court, not for the appellate.
Let us see. Let us see.
I have
Flagged.
the orange color flag.
Let's see.
It will be given.
Is one thing to be kept in mind. That if you take a stand that you are trying to hide these files from the appellants, there may be some kind of repercussion. What is to be hidden? If this is a decision which has led to their discharge, they were not given any notice. They were not given any hearing. They're at least entitled to know the reasons behind the decision.
But lot of time has expired. They could have, in the meantime, under RTI, they could have obtained it.
That's okay. If you can give it in RTI, what's the problem in instruction?
They could have filed.
Yes.
They could have filed it. I'll give you the
Now there is nothing confidential about notings. Now it's a settled proposition that even if they ask for notings, you have to give them the copies. Only on the report.
In case of orders are there.
Senior Government Counsel, Mr. Nal, on instructions has placed on, has presented the original files pertaining to the discharge of the appellants for perusal of the court. First off. Then counsel for the appellants had requested permission to inspect the files, but Mr. Nath on instructions states that he has been instructed that the inspection cannot be permitted at this stage. Inspection of the files is not to be allowed at this stage. In this background, then counsel for the appellants pray that they may be given liberty to procure the copies of the file under the appropriate provisions of law. They are at liberty to do so. List on so and so for further hearing.
The original records which were.
Original records shall be sent back to the department concerned.
Obliged.
Yes. Okay.
Production list for orders item 3.
May it please your lord. That's it. Item number 3 and 4, my lord. The analogous matters, but in item number 3, I was the writ petitioner, whereas in item number 4, there are 3 candidates. They were not party to the case, my lord. So there is a leave for appeal in the second matter, item number 4, my lord.
4. Okay.
My lord, the appellant before the lordship.
You have given us item number 4 probably. Binayak Verma.
No, my lord, the item number 3 is Chenny Bhuya, my lord.
No. 3
No, I'm
is.
so sorry, my lord. 4 is Chenny Bhuya. I'm so
Yes.
sorry, my lord. I didn't have a look at the list.
Yes.
Lordship will take up item 4 first, my lord.
Okay.
My lord, the appellant before your lordships, my lord. Her name is Chenny Bhuya, my lord. My lord, her caste, my lords, is under sub-entry 9 of entry 24 of the central list of OBC in the state of Assam, my lord. And she belongs to a T tribe, my lord, which is a tribe in the state of Assam, my lords, T tribe.
Yes.
My lords, the appellant had appeared for the NEET undergraduate examination 2023, and thereafter she was she had secured a rank of 3831, which is the state rank, my lords. And thereafter she was called for the first round of counseling. And after she attended the counseling, she was provisionally selected for admission, and thereafter petitioner went for the document verification. And after the documents verification was cleared, she was, my lords, she was directed that in a few days' time, the notification would be issued wherein she will be admitted to AMC Dibrugarh, my lords, Assam Medical College, Dibrugarh. But in the intervening period, my lords, on my lords, 5/8/2023, my lords, a complaint was filed by ATSA, my lords. ATSA meaning Assam Tea Tribe Students Association, whereby they said that these few people, they are doubtful as to whether they belong to TGL stroke ex-TGL category, my lords. TGL means, my lord, tea garden laborers, my lords, ex-TGL category. So thereafter, my lords, my admission was withheld on the ground, my lords, that my documents are sent for re-verification, my lords.
Okay.
In the meantime, my lords, apprehending that something might happen, they would cancel my admission, I approached this honorable court, my lords. After approaching the honorable court, my lords, the verification report was positive, and I was provisionally admitted, my lords, to the first year medical MBBS in AMC, and thereafter I was pursuing my classes. It's been the last 1 month, my lord.
Okay.
Well, when the matter came up before the honorable single judge, my lords, on the second day, on 19/09/2023, my lords, the single judge is held, my lords. I'll very briefly narrate what had happened, what had transpired, my lord.
Yes.
I claim, my lords, that my grandfather, he was working as a tea garden laborer in a tea estate called Noorbari Tea Estate in the district of Nagaon from the period 1965 to 1979.
Yes.
Now, my lords, when the honorable single judge took up the matter, he interpreted a notification, central government notification 1993, my lords. If I may kindly take your lordships to the notification, my lords.
Mr. Mahanta, have you served the respondents?
All of them, my lords. In fact, they were informed, my lords.
Mr. Sharma, you will be representing everyone.
No, my lord, except the medical, my lord, health department.
Mr. Buddha Gogoi, my lord, he'll be on his way. He asked me to begin, my lord.
Yes, to be here.
Deputy Commissioner,
Lordship, Mr. Buddha Gogoi is on lakes in court number 6.
All right, call him, yes. Okay, carry on, yes.
Now, my lords, lordship may kindly turn to page 109.
Just, you stated that she was admitted.
Yes.
But the para 3 of the order reads, is claiming a seat in the MBBS.
No, my lords, lordship, provisionally I was admitted. My lords, the provisional admission, lordship would find at page 19 of the writ appeal, my lords. 19.
Allowed provisional admission, yes.
In pursuance of the verification report, I was admitted.
So 1 month is not a correct statement. It's just 6 days, 7 days. 13 September. Admission date is 13 September.
Admission date is 13 September, but provisionally selected, yes, my lords.
Sure. Yes.
But nonetheless, my lords, when the matter came up on 19/9/2023, my lords, the honorable single judge,
directed an inquiry to be conducted.
No, he first of all, he interpreted the notification, the central government notification, which my lords would find at page 109. Lordship may kindly turn to page 109 for a moment, my lord.
Yes. 109 is central list of
Yes,
OBCs.
that is the central list, my lords.
Yes.
At entry 24, my lords, my lords would find it at page 110, my lord. Lordship has it, my lords.
Yes.
Tea garden laborers, ex-tea garden tribes, ex-tea garden laborers, ex-tea garden tribes as listed below. So and so, I fall in category number 9, Bhuya. My lord has it, my lord. Category number 9. Now, my lord, this notification was interpreted, if I may say kindly, my lords, that the learned single judge went on a roving and a fishing inquiry to hold, my lords, while interpreting this. He held that you may be a person belonging to the categories, my lord, the subcategories 1, 2, 3, 4, my lords. But only that would not suffice. But you have to also show that your father, your forefather, or your great grandfather was a tea garden laborer, at one point of time, my lords. And at the same time, my lords, the honorable single judge also held, my lord, in that order that your caste certificate issued by the deputy commissioner
That is
genuine.
genuine,
Is
yes.
genuine. Everything is genuine. I have been certified by the apex body of the T tribes, Assam Samosdur, to be a T tribe. But his only contention was that you have to verify, you have to give empirical proof to prove that you or your forefather or your grandfather was once working as a tea garden laborer. And with all due respect, my lords, that is not how I look at the notification, my lords. Because
So it's merely by being born in that community.
of course, my lord,
You get-
because we migrated as a tea tribe, my lords. Now we have emancipated, we are doctors, we are lawyers, my lords. But at one point of time, we migrated in the year 1834, the migration started. Now, my lords, what had happened, my lords? After coming to that finding, the honorable single judges held that all the people who have given these certificates, now they have to get a certificate from the tea garden or the tea estate or from the manager certifying that this labor had worked for so and such period.
Father or forefathers, whosoever.
Yes. Now there's this, of course, this predicament, my lords. My grandfather worked for the period 1965 to 1979. Now the circle officer inquired with the relevant tea garden, my lords. They said we do not have any records available, my lords. Well, I'll come to that point. Why do they don't have any records? If I may kindly, my lords, one thing, if I may point out, my lords. My lords, these tea garden laborers, they are divided into two categories, my lords. The first category is the permanent laborers, my lords, who get ration, medical facilities. And the other category, which is the major category, they are the contractual seasonal laborers, my lords. They are only called at the time of the plucking season, my lord, and they work on a weekly basis. And after the week is over, their register is torn and a next register is made, my lords. Because no permanent record has been kept, my lords. And even otherwise, my lords, why this contention is fallacious, my lords, if I may say so, lordship, my learned single judge didn't take into account the Assam plantation labor rules, my lord. But I have to admit, my lord, it was never placed before the honorable single judge.
What are the rules?
My lord, would kindly come.
But Mr. Why are you apprehensive of the direction? Direction is just to get an inquiry conducted.
No, my lord, I'll come to that. What had happened, my lord?
No.
My lord would come to Rule 76 for a moment, my lord. It speaks about maintaining of registers of plantation laborers, my lord. So and so, which shall be preserved for a period of 3 years after the last entry in it. Now, if I say, my lords, that my grandfather last date was 1979, it could have only been preserved for 3 years, my lord. And in any case, my lord, these tea estates, it's not like the High Court, it's not a court of record, my lord. They're private entities, my lords. After 3 years, as per law, they have to, they can, it's no longer legally required to preserve the documents. Now, what had happened, my lords? I approached the garden, the circle officer opined that we approached the garden and there was no records. Now, learned single judge in the same order, he said the caste scrutiny committee, as per Vishakha, will examine.
Madhuri Patel or Vishakha?
I'm so sorry, Madhuri Patel. I'm so sorry, my lord. I got confused.
Yes.
I had this, as per Madhuri Patel, my lord, that caste verification committee will verify all the caste certificates, but it was circumscribed. Why it was circumscribed, my lords? Because the order, my lords, had clearly laid down that you have to give empirical proof of the gardens. Now, what had happened thereafter, lordship would kindly see. Lordship may kindly come to the notice, my lords, at page number. My lords. Just give me a moment, my lords, kindly. My lords, page 21, my lords. Page 21, my lords.
Yes.
In compliance with the Honorable High Court, Guwahati High Court order in WPC so and so, 19-9 so and so, you are directed to appear before the state level scrutiny committee for verification so and so. Lordship would come to 4.
Certificate from manager.
Circumscribed, my lords. The scrutiny committee did not apply its own mind but they proceeded on the.
Mata, that seems to be reasonable. Otherwise, every person having
Yes.
Bhuyan as a caste,
No,
wake up and
Exactly,
procure a certificate.
exactly.
So that's perfectly logical,
Lordship,
rational.
Lordship is very correct, but
Yes.
what, well, I'm trying to
So if you're
submit. my
trying to take advantage of that reservation.
There is
You have to have empirical proof.
there
What
is
is wrong in it?
no, well,
Because the caste alone cannot be the criteria.
right. With that caste itself, my lord, just because of the fact I'm a tea laborer.
You have to establish that.
Yes, yes,
Without, so that is what the
Right.
single judge says that at least there has to be some kind of
Perfectly, my lord. Perfectly. I totally
acceptable
understand what your
proof.
lordship is. But my lord, there is a legal mechanism which is already established. Now, my lords, with all due respect, the deepest respect, my lords, there cannot, honorable single judge could not have evolved a new procedure altogether. Now, my lords, what would happen? 79, there will be no records, my lords.
So,
I proved it
so
from
then,
the law,
yes,
my lords.
that's what we are saying.
Yes.
Any person
Yes.
whose grandfather was alive between
That-
those years would wake up and
Yes.
say, but I am a tree garden laborers.
No, my lords,
offspring.
because my lords, it's a distinct identity. Like, for example,
Based on what?
yeah, my lords,
What is the foundation?
yes, lordship would come to page 89 for a moment, my lord.
Yes.
When the honorable single judge has held that the certificate is correct. 89, my lord, kindly. This is the certificate issued by the
Yes.
deputy commissioner or the district commissioner, who's the authority as per Madhuri Patil, my lord. Lordship would see this is to certify that Chaini Bhuya so and so, so and so, so and so, so and so, so and so belongs to the Bhuya tea garden laborers, tea garden tribes, tea garden laborers, tea garden tribes, caste
What does the
community.
state have to say about this certificate, Mr. Sharma?
The
What
court
is the
has held
stand of the
statement,
state
my lord.
on this certificate?
Court a genuine validation.
You, the state's affidavit, where is the affidavit?
Notice was never issued in the matter, my lord. In
There
fact,
is no affidavit. That is why, my lord,
no chance, my lord,
we have not.
It's little difficult. Without getting the response of the state, the things have been virtually foreclosed. That is causing a problem. Then,
In fact, learned single judge observed, my lord, this certificate has been issued, my lord, prior to issuance of the certificate by the team of
no, my lord would come to the caste certificate, what the learned single judge has held.
yes, the tea garden certificate is subsequent.
Page 15, para 15, my lord. Para
Yes.
15 of the
Where
page
we have read,
53.
we have read that, yes.
Page 53, I'll read it out, my lord. The guidelines further provide that in case the doubt arises on the author, the next paragraph. From such point of view, the certificate that the writ petitioner Chaini Bhuya relies upon would have to be accepted to be an authentic certificate, in as much as it is issued from the office of the Deputy Commissioner Nagaon and is supported by some further certificates by the Assam Cha Mazdoor Sangha. The only thing which the learned single judge was harping upon, that you give evidence, my lord. My
No,
lord,
no.
there are-
What has been noted is
Yes.
that the certificate of your tea estate is subsequent to this, subsequently
Yes,
issued.
it can be, my lords. There are other certificates also, but the Assam certificates, my lords, would find. But that was not the issue here, my lords. The caste certificate at page 89, Gaon Buda, the Gaon Pradhan at page 90, page 92, the Assam Cha Mazdoor, which is the apex body, my lords. My lords, there are tea gardens which have been closed. The honorable single judge has held, you go to the owner of that closed tea garden and you ask him whether there is some record.
Mr. Sharma, laying down the procedure for the committee, the procedure is already laid down by Honorable the Supreme Court. So whether the single judge, without getting the response of the state on the basis, on what basis this certificate was issued, could have relayed the procedure. Little bit of doubt. What have you sought in this appeal?
As per the last order, my lords, 27, learned single judge had given a clarification that tea manager would include tea authorities and the learned single judge has held that you, if the people are found, they
We'll
don't have
hear
the
you,
evidence.
we'll get your response here only. And in the meantime, we'll save our admission.
It's supposed to be cancelled, my lord. The notification
Issue
issued
notice.
yesterday evening, my lord.
Only thing,
My
my
lord,
lord,
pursuant to the order of this honorable court, the admission of the present writ appellate have been, my lord, cancelled by the DME because there is a direction will.
It's absolutely illegal.
Yesterday-
Till now, where is the report of the committee? Where is the report of the committee?
I have not been furnished, my lord.
It's not yet there, not yet issued. Then how could you cancel?
My lord, the committee report was furnished to the director of medical education as well as the order of this honorable court.
Well,
That part I leave it to your lordship.
This matter has to be examined.
Yes.
Issue notice to the
Only
respondents.
thing, my lord, tomorrow is the last date for completion of admission.
We are protecting our admission. issue notice to the respondents when counsel Mr. Manta submits that the learned single judge, interfered in the certificate. What was the reason for you to file the writ petition?
Because initially it was withheld for re-verification, my lord.
Where is that withholding order?
Withholding order, my lord, would find 13-9, page 19, my lord.
So this was the admission granted.
No, my lord, withholding is, it's there, my lord.
Where is the withholding?
Page 123.
Mr. Manta submits that the appellant herein belongs to the OBC within bracket ex-Tea Garden Liberal community within Buyan community, and thus, she is entitled to reservation under the subject admission process to the first year MBBS/BDS courses in the government medical and dental colleges of Assam. She was provisionally admitted by order dated 13/9/2023 within bracket annexure A. Subsequently, acting on a, where is that order?
My lord, the order dated 19/9/23.
Where is it?
Page number 46, my lord.
Subsequently, this is the writ court's order. Where is the order whereby your admission was stayed or whatever?
Withheld, my lord, that is, my lord, would find 123, my lord.
Thereafter, acting. What does it say? Yeah, thereafter, and this is notice dated 3rd September.
Yes, my lord.
So what after 13 September?
It was withheld and thereafter I was again allowed to provisionally.
No. Then what happened?
Then, my lord, the order was passed in 19/9, order was passed. Thereafter,
why were you supposed to come? Who came in it?
I came because it was withheld, my lords. I immediately approached the Honorable High Court, and after filing it, my lords, I was again provisionally admitted, my lords. Thereafter, my lords, 19/9 order was passed.
Take it like this. Submit that though the petitioner should have been declared selected on the basis of in the reserve category TGL/ex-TGL, her result was withheld by communication/admission notice dated 3rd September 23. Pursuant thereto, a provisional admission order dated 13th September 23 was issued in favor of the appellant. What thereafter? Why you approach this court? We don't understand.
Because my admission was withheld, my lords.
Where is the withholding order?
My lord, it's 123, my lords.
Oh, that is 3rd September.
Yes, my lord. After 3rd September, I approached this court, my lord. After filing, I was provisionally admitted.
When the result of the petition was withheld, she approached this court by way of the caption writ petition. What is the date of filing of writ petition?
I'll inform it, my lord. Sometimes in September, the affidavit.
Writ petition number so and so. First off, while the writ petition was pending, the authorities issued a provisional admission order dated 13th September 2023 in favor of the appellant. However, the learned single judge, has directed re-verification of the caste certificate of the appellant herein issued by the competent authority, that is the Deputy Commissioner Nagaon, by laying down certain criterion, additional criterion, which are not provided in the judgment of Honorable Supreme Court in the case of Kumari Madhuri Patil, so and so.
Citation.
He urges that without even seeking the response of the respondent state on the certificate issued by the Deputy Commissioner, a fresh verification exercise has been directed in a manner which is not prescribed by law. First off, issue notice to the respondents, so and so put in appearance. They pray for and are granted 3 weeks time to file affidavit in this writ appeal. In the meantime,
Cancellation notice 26.
cancellation notice
Page
dated
26, page 20, dated 28/09/2023. Yes,
Can-
Your Honor.
notice of cancellation of admission issued to the petitioner dated 28/9/2000, petitioner appellant 28/9/23 shall remain in state. We can dispose of the appeal. Let the single judge decide.
My lord, he has already made up his mind, my lord, that.
All right, then let the in view of the peculiar facts noted above, we further direct that proceedings and since, the matter has been taken up by this court in the appellate jurisdiction, the proceedings of the writ petition number 5340/23 shall remain in abeyance.
My lord, the next, my lord, we're not even parties to the writ petition, cancel unilaterally, my lord, same ground. Because
There is a
that-
cancellation,
My lord, same cancellation order, my lord.
same.
But there is a leave for appeal, my lord, because we were not parties. I mean,
Appellants herein who are provisionally selected candidates
ex-TGL, TGL, my lord.
under the so and so category, TGL X TGL category, are aggrieved by the order. There is a appeal file.
Order dated 28, my lord.
Communication dated 28/9/2023. Not registered. Passed by the learned single judge, passed by the state authorities based on an order dated so and so, passed by learned single judge of this court in writ petition number 5340/2023. First of since the appellants have borne the brunt of disqualification from admission without being impleaded as a party in the said writ petition, we hereby accept this application. We further observe that effect and operation of the order dated 28/9/23 has been stayed by us by an order passed in writ appeal number so and so. Thus, the admission of the petitioners appellants herein shall not be cancelled pursuant to the notice dated 28/9/2023. The writ appeal shall be numbered and listed for admission along with writ appeal number so and so on. When should we post it?
After puja, my lord, after.
How much time would be required?
My lord, after 15 days, my lord.
On so and so, we make it clear that the protection being granted to the appellants herein is provisional and shall not create any lien in their favor. Re-notify on 16th November.
I'm very grateful, my lord, deeply obliged.
My lord, one thing may I submit, my lord, as per the, my lord, middle third judgment of the Honorable Apex Court, after 30th September, there cannot be any midterm admission. If at all, my lord, they are found to be, my lord, not genuine, their admission.
They'll have to go. They'll have to go. There's no way out.
Yes.
That's we already made it clear. No lien in their favor.
Deeply obliged. All right.